Hey everyone, welcome to today's video. Today we're looking at a situation from divorce court involving someone whose behavior is a strong reminder to be careful about who we get involved with. I came across this clip on a channel called Law Talk with Mike, and if you're not already subscribed to him, you might want to check out his content after this video. He covers a lot of interesting courtroom moments, and this one definitely stands out. So, let's get started and take a closer look at what happened.
Good morning. How are you all?
Morning, how are you?
Morning.
Are we waiting on anybody?
No.
Okay, what can I do to help you all today?
Yes, sir. Get us off of your docket is what you could do.
Alright, Karen, you can keep talking to the court like that if you want, but you're really pushing your luck. A regular civil divorce case can easily shift into a criminal contempt case if you keep showing disrespect in front of the judge. All it takes is a few more comments like that, and the situation will move far beyond the paperwork you originally came in for. Courtrooms expect basic cooperation, and ignoring that can create problems that didn't need to exist in the first place.
Go ahead, Lacey. Start talking.
That's pretty specific. Ms. Kimball?
Yes, sir. Specific.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
I can easily understand why your previous lawyer decided to step away from your case. But just so you know, the court isn't required to give you a new attorney for a divorce case, and they won't appoint one for you. Divorce matters are handled differently from criminal cases, so you're expected to either represent yourself or hire your own lawyer. It's important to stay calm and focused, because the judge can only work with the information and cooperation you provide moving forward.
Just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrawed, and I'm going to need one appointed by the state.
Karen, please stop talking for a moment. There will be an appropriate time for you to make your objections, and you'll have your chance to speak when the judge allows it. Right now, though, this is not the moment to interrupt or argue. If you continue jumping in at the wrong time, you're only going to make the situation harder for yourself. Staying quiet until it's your turn will help the court move forward smoothly and keep the hearing on track.
That's not an option. There's nothing there, unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me, or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions, and then we ultimately never got a response, and she filed a motion for protection.
She got plenty of responses. Objection.
Did you really just admit to doing something illegal right in front of the judge for no reason at all? That's the kind of information you should never volunteer unless you're specifically asked about it. Saying something like that in open court can create problems you didn't have before and may even change the direction of the entire hearing. It's always best to think carefully before speaking, especially when every word is being recorded and taken seriously.
How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She also represents Cody and also fucking sit there.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So Ms. Kimball, why don't you just go ahead and finish telling me what, so you said that you're wanting a drug screen, so a drug test, and do you say psychological or psychiatric? I thought you said
psychological exam. And then we have a order to compel Ms. Stiles to turn over the responses to our discovery request to provide dates for a deposition and for attorney's fees for $1,500.
All right, so Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front I'll fall for marijuana.
I'm sorry to be the one to point this out, Karen, but take a look at the flag behind the judge. That's the state flag of Texas, which means you're definitely not in California. And in Texas, the laws are very different. What might be allowed somewhere else isn't necessarily allowed here. So mentioning anything about substances that aren't legal in this state is only going to create more issues for you. It's important to understand where you are and what rules apply before you speak in court.
When was the last
But
time?
I'm happy to take it on
When was the last
expense.
time you took marijuana?
I use marijuana daily. All day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight.
No, the judge isn't forcing you to do anything outside the scope of your divorce case. He's simply making decisions that are legally allowed when a person's behavior raises serious concerns. Right now, you're acting in a way that suggests you're not thinking clearly, and it's understandable why the court would want a professional evaluation. When someone appears confused, agitated, or unstable during a hearing, the judge has a responsibility to make sure they are capable of participating in the process. A psychological evaluation is meant to protect you, ensure fairness, and help the court understand what's really going on.
So I'm glad to take the drug test.
Stop.
Okay, go. It's going to be on his expense,
Stop.
but I'm
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful.
I'm
So
fed
you can
Kimball.
just, if you're gonna use
Respect.
my last name, that's
Okay.
fine. Just say Judge tonight. Okay, it's pretty easy.
Okay.
So you use marijuana all day, every day.
Not really day every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge tonight.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
Not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no?
You're going to need to answer his question again, because he's the judge, and he's the one leading this courtroom. Whether you agree with him or not, you're expected to respond respectfully and follow the process. Arguing or avoiding his questions isn't going to help your case. It will only make things more difficult for you. Showing a little patience and cooperation will go a long way in keeping this hearing on track.
Do you agree or not agree?
You don't get to ask me questions right now. I'm asking your
That's
your position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your goddamn question.
Based on the way you're acting right now, and considering that you just asked the court for a state-appointed attorney, it's pretty clear you're not in a position to keep paying these repeated fines. Each sanction adds up quickly, and they aren't cheap, so continuing down this path is only going to create more financial trouble for you. This would be a good moment to calm down, stay focused, and cooperate before the situation gets even more serious. If you don't, the court is going to move forward in a way that may not work out in your favor, and avoiding that should be your priority.
So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I can. I would propose.
And whose expense? Mine? Because if it's mine, I'm not fucking doing it. Sanction, give me $100 fee. Woo
Okay,
woo.
well,
That's actually kind of amusing. Karen seems to have completely misunderstood what the judge was asking her. It's as if she thought he was asking something totally unrelated instead of a straightforward question about the case. Moments like this show how disconnected she is from what's really happening in the courtroom. When someone misunderstands even the simplest questions, it makes the process slower and far more frustrating for everyone involved. Staying focused and listening carefully would save her a lot of unnecessary trouble.
so I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order, as I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're gonna want.
Stop. That's not something that she asked for. Ms. Kimball, what dates?
No,
what
been
date are you
everybody
requesting?
else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting how long? That's a valid question. Is it half day, an hour, 2 hours? What are you
I
anticipating?
would anticipate a full day.
Okay.
So what? The
Ms.
30th or the 2nd?
Which of those dates works better for you, Ms. Stiles?
What time, dumbass? 3 contempt.
Well, it looks like Karen won't be around to defend herself for the rest of her divorce hearing. And yes, the trial continues for another 20 minutes even after she leaves, which only makes her situation more complicated. Walking out of a court proceeding never helps, and it usually leads to decisions being made without your input. It's a reminder of how important it is to stay present and handle things properly when the judge is involved. Alright, everyone, that brings us to the end of the video. If you enjoyed watching, feel free to leave a like, and if you didn't, a dislike is fine too. Make sure to drop a comment below and subscribe with notifications turned on so you don't miss any future content.